Conference aims to delve deep into the challenges plaguing our justice system with the hope of converting meaningful conversations into definitive action. From diverse fields, including judicial experts, police officers, economists, academicians, civil society, and the media, to deliberate on ways of strengthening the justice system and making our institutions deliver better results. For today's inaugural ceremony, we are delighted to have with us Justice Venkatachalaya, former Chief Justice of India, Dr. Duvuri Subbarao, former Governor, Reserve Bank of India. From our partner organizations, we have with us Professor B. Raj Shaker, Pro Vice Chancellor, University of Hyderabad, Professor Ashwini Chatre, Associate Professor, Bharati Institute of Public Policy, Indian School of Business. Thank you to all the esteemed guests for joining us. Finally, we have Dr. Jayaprakash Narayan, General Secretary of Foundation for Democratic Reforms. We thank you for driving this initiative, sir. I would now like to outline the inaugural session program. To begin with, Dr. JP will give the welcome address. We will then have an inaugural video, followed by opening remarks by Professor Raj Shaker. The inaugural address, which Dr. Subbarao will deliver the keynote address. Finally, Professor Ashwini Chatre will extend the vote of thanks. If time permits, we will have a question and answer session, so please put your questions in the chat box, if any. I now call upon Dr. JP to deliver the welcome address.
Friends, on behalf of the Foundation for Democratic Reforms, University of Hyderabad and ISB, I welcome all of you on this Saturday morning for this very important conference on rule of law. We have two exceptional people. In Justice Venkatachalaya, we have a venerable jurist, the greatest that we have today in India, and a great thinker, philosopher, and a fountain of wisdom to bless us and guide us in the inaugural ceremony. Thank you, sir, for participating. And we have in Dr. Subbarao an exceptional civil servant, a central banker, a man who has deep understanding of governance and economic issues. We believe that our conference is not merely about justice in a constitutional sense, it's also about economic growth and creating opportunities for the people. Therefore, it is fitting that these two great intellectuals and thinkers and practitioners will be participating in the inaugural session. We thank you both. Democracy is a work in progress. It requires constant vigilance, review, and renewal. Foundation for Democratic Reforms therefore partnered with two prominent and reputed institutions, the University of Hyderabad and ISB, to launch this initiative of Indian democracy at work. This is the second in a series of conferences. Last year we had a conference on money in politics. This year we have chosen this theme with great optimism. Our approach is to search for solutions, optimistic, rational, and pragmatic solutions. And to be a part of the solution, not be a part of the problem of complaining and wailing all the time. And to bring all the stakeholders together to find workable solutions, recognizing that the impossible best is often the enemy of the possible good. Therefore, a pragmatic approach of what works. This conference has about 50 eminent practitioners and thinkers in the field of rule of law. Last and it's easy for people to do good and difficult to do evil. That is the first order of business of any government, modern or medieval or ancient. Our society is strong and stable. Our people are peaceful and tolerant at large. And therefore, happily, our crime rate is pretty low. It's about 377 per 100,000 population. As opposed to, let's say, OECD countries, which have about 10 to 20 times this crime rate. And yet, we have 27 million criminal cases pending in courts. Over 60% of them are more than 1 year old. Unlike other countries, our civil cases are far fewer than criminal cases. What it means is that people are shunning courts, they're avoiding courts. We get about 1 crore or so criminal cases in a year. We get about 40 lakhs or so civil cases in a year. Even then, 10 million civil cases are pending in courts. People don't go to courts if they can possibly avoid it. They prefer to suffer silently or find extrajudicial solutions, breeding an industry of settlement, criminal gangs, and of course, promoting corruption and injustice and mistrust. Annual disposal of judges in courts is pretty high. Our trial courts dispose of more than 800 cases in a year, each judge. The High Court judges give an astonishing 3,500 orders in a year. We cannot ask from judges much more in terms of the volume. The quality of justice is a different matter, because no judge can reasonably be expected to give sound and reasoned orders in 3,500 cases in a year, however Solomon-like he or she may be. So far, India has been relatively crime-free. We are fortunate. In a rural, networked society, the family and community bonds made sure that the behavior of most of the people is predictable and peaceful. These social controls ensure that crime is low. But with rapid urbanization, anonymity, impersonal lives, social controls cannot always protect us. Crime is bound to rise, and there's already evidence of that in urban areas. Similarly, with more economic activity and growth, there are bound to be more economic interactions. Therefore, more disputes and contracts. Therefore, more need for resolution and dispute settlement. And if they don't get settled in a fair and just and speedy manner, then people suffer silently or look for other recourses. Mistrust rises, might becomes right, people become risk averse, investment comes down, growth suffers, poverty continues. The rule of law, therefore, we believe, is not merely a constitutional and justice issue. It is a serious economic issue. And that's the reason why the two distinguished speakers in the inaugural session represent the two facets of rule of law, the constitutional norms and justice, and the economic growth and linkages with rule of law. The challenges are many, but they can be addressed in a practical way. There are some obvious things which require to be addressed. We have the lowest number of policemen per unit population, about 156 per 100,000 population. We have the lowest number of judges, about 14 per million population. We have the lowest number of prosecutors, about 6 per million population. We have the weakest forensic infrastructure, a capacity of only 20,000 cases per year. DNA sample analysis, for instance. Our procedures are complex and slow. Crime investigation is often partisan because it's entirely politically controlled. No wonder. According to the World Justice Project report, in the Rule of Law Index, India ranks 69th out of 128 countries. Civil justice, we rank 98th. Criminal justice, we rank 78th. We have the lowest conviction rate of about 50%. A majority of convictions are based on confession, mostly by the poor and the weak who cannot afford a lawyer. Contract enforcement, we have the longest duration, 1445 days among significant economies in the world. 70% of our inmates in prisons are under trials. Obviously poor, who cannot afford a lawyer. Third degree in police stations is all too common, to extract a confession or sometimes to provide extra legal justice. Total expenditure on rule of law in the country is only about 0.76% of the GDP, under half of what many civilized countries spend. The expenditure on courts is only about 0.1% of GDP, about 1/4 of what other countries spend. These numbers show that there's a crying need for urgent reforms and meaningful reforms. The focus of this conference is not on the whole gamut of rule of law. The constitutional aspects and holding the government to account are much larger issues. We are focusing on much more practical and simpler issues for want of time. The police, the prosecution, the procedures, and the courts, both criminal justice and civil justice. The police, infrastructure, forensics in particular, community policing, and can we shift 20% of the crimes to a special investigative agency like the CBCIDs we have in states and make them insulated from political vagaries and professionally competent with adequate infrastructure, empowerment with accountability. As I said, the impossible best is the enemy of the possible good. If you want to take away the whole police outside the elected government's jurisdiction, there are going to be serious dangers. I remember vividly today's Chief Justice Venkatachalaya. Once he admonished me when I was arguing for police reform. He said, ours is a system of compensatory errors. If you want to set things right in one branch or one area, make sure that the rest of it is also okay. Otherwise, you may create more of a problem than a solution. The remedy may be worse than the disease. So a pragmatic approach to get a buy-in for all the key players. Prosecution, extremely weak, and of course partisan. Therefore, strengthening prosecution, bringing judicial officers at the district level as district attorneys to head the prosecution wing, and they go back to judiciary again, they come on deputation, ensuring independence and better coordination, and an independent investigation and prosecution board at the state level to guide both investigation and prosecution. Procedures, many commissions and committees and experts have suggested several amendments to CRPC, CPC, and Evidence Act. And judiciary, local courts to take the bulk of the simple cases through summary procedures in a time-bound manner, enhancing the number of judges and courts and infrastructure, better case management, and a one-time effort to get rid of the pending cases because the judges are completely crushed under the burden of pendency. And on average, at the trial court level, there are about 3,000 cases per judge pending. At the high courts level, an astonishing 8,000 cases per judge pending. And therefore, some serious efforts are required in the short term for 3-4 years to overcome this burden of pendency. We are a federal structure. We are a robust federal society. With all our imperfections, India has improved federalism greatly. We are much more mature federalism than we were 30 years ago. Most of rule of law and justice administration are in states. Evidence shows that just because there is a national effort, it does not necessarily get translated into outcomes at the state and local level. The former Law Commission chairman, who is chairing one of the sessions in this conference, he pointed out to me that Section 25A of the CRPC was amended way back in 2005, providing for a very professional and competent director of prosecutions in each state. Despite the amendment of the law, many states have not followed suit. FDR looks at themselves, fought for years to get a local court law in place. In 2008-2009, a law was enacted by Parliament providing for rural local courts, though we wanted local courts across the board. We hope that 5,000 to 6,000 local courts will be created to deal with simple cases in a summary manner. So far, only about 200 plus courts are in operation. So it's not enough to come up with solutions or even to enact laws. There are 4 key questions. One is what to do. That's what this conference will address. Then how to get a buy-in in all the key stakeholders, the police, the judiciary, elected representatives. They have a legitimate stake in rule of law, in a crime-free society, in maintaining order. But where exactly should that line be drawn is something very important, and we have not yet found that line effectively in our country. And of course, the states and the union, how to bring them together on board, work in coordination in a very polarized and partisan environment. How to get legal and institutional framework in place, the third great question. The fourth is, after they are in place, how to make them work. At the end of the day, the proof of the pudding is in the eating. This conference is a search for solutions. It's to provide a roadmap, and it's to build a consensus. And we hope that after the conference, we will together pursue and persevere with optimism. I welcome the eminent speakers and the participants for this very important conference. We genuinely hope that this will make a difference. We are optimistic truly. We believe if something must be done, something can be done, then it will be done. And this must be done, this can be done, and I believe this will be done. Not in one day, it may take a few years. Not all of it may happen overnight. Some of the things may happen earlier, some may happen later, but we must persevere and get these things done. It is with this spirit that we invite you all for this conference. We thank you, both Mr. Justice Venkatachalaya and Rao, and the partner institutions, the University of Hyderabad and ISP. And my appeal to everybody is after the conference, it's not merely a 9-day affair with about 15 or so sessions and 60 plus speakers and thinkers participating. It is about making these things happen together collectively. Therefore, collective, informed assertion in a responsible way, in a constitutional way, is the key. We hope this is a part of the process. Once again, thank you, sir, Justice Venkatachalaya Garu, and thank you, Dr. Subbarao Garu, for participating, for blessing us. Over to you, Sumedha.
Thank you, sir, for highlighting the practical significance of rule of law and setting the tone for this conference and beyond. We will now have the inaugural video.
A modern government is to maintain order, control crime, punish criminals, and settle disputes. We are a relatively peaceful society, but we have serious problems in enforcing rule of law. In Tamil Nadu, in 2020, a father and son were brutally tortured for violating COVID lockdown restrictions, which resulted in their deaths. In Gurugram, in 2018, when a school kid was viciously murdered, the police arrested Ashok Kumar, the bus conductor, tortured him and extracted a confession. Weeks later, CBI investigated the case and found the real culprit and declared Ashok Kumar as innocent. In Hathras, UP, a young lady was raped and murdered, and yet the administration did everything possible to suppress the incident and protect the perpetrators. In Hyderabad, a young veterinary doctor was gang-raped and brutally murdered. The police were under tremendous pressure to provide instant justice, and the accused were killed in an extrajudicial execution. Dreaded gangster Vikas Dubey from UP faced a similar fate after being shot down soon after his arrest. In the case of the suspicious death of Sunanda Pushkar, it took over 2 years to get a DNA analysis done. Tellingly, the trial in the case of former Prime Minister Rajiv Gandhi's assassination took over 6 years. These few random examples illustrate the failure of rule of law across many levels: investigation, infrastructure, procedures, prosecution, and trial. Speedy and efficient justice, resolution of disputes, equality before law, and supremacy of law are vital for a civilized society for very practical reasons. In a village society, family bonds, caste networks, and social pressure moderated behavior and controlled crime. But with urbanization and migration, strangers now live in close proximity in densely packed cities. As social controls weaken, crime is bound to rise. If we have no capacity to forge links with the community, detect and punish simple crimes, and apply modern, scientific methods of crime investigation, and do all this in a credible, fair, non-partisan manner, crime will be uncontrolled. Society will be paralyzed by fear. Life will be unbearable. Similarly, disputes are bound to rise in a growing economy which will have multiple contracts, commercial transactions, and interactions. If there are no credible, speedy, inexpensive mechanisms to resolve disputes, mutual trust will collapse, people will be averse to risk, investments will fall, growth will suffer, poverty will continue, frustration will rise, society will be in peril. Unlike other major countries, criminal cases far outnumber civil cases in India. This skewed ratio in a society that is relatively peaceful and crime-free shows that most citizens avoid courts to settle civil disputes and instead resort to extra-legal methods or suffer injustice silently. Failure in addressing this situation would lead to grievous consequences. Anecdotal evidence from cities like Johannesburg, Mexico City, Lagos, Karachi, Lahore underscores that in the absence of robust rule of law framework, lawlessness will prevail, crime syndicates will mushroom, and life will be a living hell. Rule of law is not an esoteric constitutional concept. It's about people's daily struggles, about peace and harmony, about opportunities. It's a matter of life and death. There are aberrations in our rule of law instruments, but these can be set right. Various committees and commissions have suggested several practical, acceptable, and effective measures to strengthen our rule of law instruments, which will be discussed in this edition of the Indian Democracy at Work Conference on Rule of Law. Let us now take a look at some key areas of reforms. As social controls are weakening, the role of police in maintaining public order and controlling crime is more important than ever. The police, based as they are on primitive methods and obsolete procedures, are, however, often ineffective. While it's easy to blame the police, we must recognize the challenges of modern policing. The Indian police force, with a strength of 156 policemen per 100,000 population, is overburdened owing to multiple duties. Most other democratic countries have more policemen with great deal of specialization in functioning, backed by state-of-the-art technology. Police are not merely overstretched, they are also handicapped by woefully inadequate infrastructure, particularly the forensics. The annual DNA testing capacity in India is just over 20,000. Typically, in a major crime, 6 DNA samples are tested. Delhi alone witnesses around 11,000 violent crimes in a year. How can one expect the police to be effective when the support system is primitive? As a result, the police are under tremendous pressure to produce short-term results by hook or by crook to appease the public. Further, in an era of political polarization and contentious public discourse, the governance issues morph into law and order challenges. This puts the police in a difficult spot where they have to maintain order without resorting to excessive force or stifling legitimate protest in a democracy. The fusion of multiple functions in a single police force has weakened rule of law. While maintenance of public order and riot control require political supervision, crime investigation is about collecting admissible evidence to be able to get a conviction in a court and is therefore quasi-judicial in nature. It must be free of political interference. An independent crime investigation wing to investigate certain grave crimes is the need of the hour. They can be entrusted to probe crimes for which maximum punishment is more than 3 years of imprisonment, which amount to only 20% of total crimes in a year. To guide the investigation and secure a conviction, an independent prosecution wing must be created, headed by a district attorney drawn from the judiciary, a sessions judge working on deputation for a period of 5 years. Such a system will bring in the benefits of independence, better coordination between the police, prosecution, and the courts, while also enhancing the stature of prosecution. At the state level, an independent investigation and prosecution board will supervise all investigation and prosecution. If we consider case load for serious crimes in the country, the number of crime investigators and prosecutors is far less than the optimal strength required. In the US, the number of investigating officers per 100,000 population is 32.18, while it is 1.74 in India. The number of prosecutors per 100,000 population is 17.63 in the US and 0.67 in India. No wonder the conviction rate in India is abnormally low, with only 50.4% IPC cases resulting in conviction, most of which, presumably, are based on confessions. Providing adequate manpower and forensic facilities at the district level is a critical minimum requirement. Over 34 million cases are pending in our trial courts, with most cases taking far too long to be resolved. It takes about 1,445 days on an average to enforce a contract. That is too long a period to inspire the confidence of even the most courageous investor. Outdated procedures are a significant cause of this delay. Recommendations made by various reports of the Law Commission and other expert bodies must be implemented to address this challenge. The consequences are perhaps more apparent and immediate on the criminal side. Indian prisoners witness an alarmingly high proportion of under trials at 70%, which further results in overcrowded prisons. It is high time that the recommendations made by the Malimat Committee are adopted. Moreover, we only have 14 judges per million population, whereas the global norm is 50 or more. As a matter of fact, a trial court judge in India disposes of 824 cases in a year compared to 159 in the UK. In such a situation, it is neither realistic nor fair to expect the courts to function optimally. To make justice more accessible, the Gram Nyayalayas Act was enacted in 2008 to establish local courts in rural areas. At the proposed rate of one court per block panchayat, there should have been 6,000 such courts by now. However, only 395 have been sanctioned and mere 221 are functioning. These courts need to be set up on priority across the country, including urban areas, where the need for such courts is even greater. High courts are inundated with litigation. There are 5.6 million cases awaiting a final decision before 673 High Court judges in the country. In 2019, the disposal rate per High Court judge was an astonishing 3,500 cases. This is a reflection of the many challenges that our High Courts are facing: high vacancies, overcrowded dockets, and inadequate infrastructure. Although entrusted with the authority to adjudicate on matters of constitutional importance, these courts are currently unduly burdened with appellate and divisional matters, which account for 40% of their caseload. All four areas, police, prosecution, procedural law, and courts, are crying for urgent reform. We only spend about 0.8% of the GDP on rule of law, whereas most other democratic societies spend about 1.8%. Expenditure on rule of law must be taken as investment in society. Neither peace, nor harmony, nor stability, nor economic growth are possible without rule of law. This conference is a humble attempt to bring all stakeholders together to look for pragmatic reforms consistent with speedy justice and citizens' liberties.
I now invite Professor Raj Shaker to give his opening remarks.
A very good morning, respected Professor Venkatacharya garu, Dr. Duvuru Subbarao garu, Dr. Jayaprakash Narayan garu, Professor Ashwin Thatre garu, and the delegates attending this conference. It's a pleasure to be part of this conference on Indian democracy at work, organized by Foundation for Democratic Reforms in collaboration with Indian School of Business and University of Hyderabad. So in the introductory remarks, Professor JP has given a lot of insights and statistics, realities, and also the video, whatever we have seen now, has brought a lot of issues, how we can go forward, and what is the relative position of India in compared to developed countries and other developing countries, and what is the presented a status report. And now at this point in time, the Democratic Foundation for Democratic Reforms has brought a advocacy paper that is rule of law for the 21st century. I have gone through the paper, so it is almost taken every aspect and took a lot of time to provide a lot of statistics, and these statistics are clearly saying that, and most of the friends, we need to improve a lot. That is what I could see. And also, as Dr. JP said, the under trials imprisonment is one, and people who are in the jail and who are waiting for trials. And also why most of the time people are not into police stations, how these cases are being handled. So these are various issues we have seen. Now, I also appreciate Dr. JP saying that we are very optimistic, we are very positive. We would like to give the solutions and rather than being part of the problem. I think that would be the very nice gesture. And we are also very, very optimistic that, definitely we will improve. And most of the time, the statistics, whatever we see, so they're also subjected to a lot of corrections, meaning saying that, that less crime rate in India. So as is only based on the reported cases. But why many of the cases are not reported? So that is one important issue. And also regarding the balancing between the economic growth and social justice, that is the need of the hour. As a country of 130 crore population and having a lot of complexities in the society, hierarchies in the society. So how do we address the requirements and needs of the people who cannot afford, who are below poverty line? And the kind of a system, the governance, what we have been looking at is we expect the government is supposed to be more objective and concerned with the bottom of the pyramid. And also the kind of rule of law, whatever we are saying, it should also prevent the governments to be, the states to be authoritative. So as we said, everybody is equal before law, including government. And also the governance, when we are speaking about how do we make our governance more and more objective, for which I know there are eminent speakers are here. So I do not want to venture into giving some solutions to this problem, but I also feel since I have been doing research in service quality, so I was also looking at some kind of a scope for bringing some of the metrics, what we do in service quality, because the government is also providing service to the public. So there we have a very popular scale called RATER, RATER, proposed by Professor Parshuraman. It speaks about the various 5 components. One is reliability, second one is assurance, third one is tangibles, fourth one is empathy, fifth one is responsiveness. I think, when I'm going to this paper, advocacy paper, I think it is more or less fitting into that. We have been speaking about reliability in settling the issues in governance, assurance to the stakeholders, the tangibles, that's where we are speaking about the infrastructure, and empathy. So people who are handling these issues, they should be more empathetic towards the stakeholders, and responsiveness of the system. I think that these 5, service quality, we have been speaking about the stakeholder satisfaction, and to measure the service quality, we use these metrics. So I think, if you bring this kind of a scale, even for rule of law, I think we are going to get more insights how, because most of the things what we have been discussing are fitting into that. And also in quality, when we discuss about to enhancing the quality, especially may not be necessarily in a kind of a service sector, but of course in service sector also it can be applied. That is something to do with FMEA, failure mode and effect analysis. So this is where I think we need to look at when we are looking at possible failures, and what is the mode of the failure and what is its effect, and make a kind of a analysis and come out with some kind of a solution, a concrete solution. And Dr. JP has been telling that we should treat the disease, not the symptoms. I think most of the time we have been discussing about the symptoms, but treating the disease is very, very important. That's where again in quality, when I refer something called root cause analysis, I think we need to go to the root cause and where it is. And also there are a lot of things about in management also we speak about in problem solving process, the cause and effect analysis. So what are the causes and what are the effects? So that's where I could see, of course, our friend from ISP, from public policies here. So I could see a lot of kind of a collaboration can happen between management, political science, public administration, public policy, and also law and judiciary matters. So in this context, I think, academic institutions like University of Hyderabad and ISP and the Foundation for Democratic Reforms, I think all of us can come together. Now, the national education policy is also speaking about the cross-disciplinary, multidisciplinary kind of education. I think now we need to also explore the possibility of floating a kind of a course, and a kind of a course on these kind of issues. I think, they can be like now today post-COVID, we have been into this blended teaching and the synchronous and asynchronous. I think, these three organizations together, Foundation for Democratic Rights and University of Hyderabad and ISB, we can start a kind of a course to begin with. Subsequently, we can go for a program. And it is also a kind of a social responsibility, I can say, the institutional social responsibility where ISB and University of Hyderabad. So I think, we should also take little lead. Definitely economic growth is important, but economic growth at what cost is also very important. And we have been seeing in this advocacy paper that, how this migration, industrialization, they have been causing this kind of contributing towards crime. So how do we need growth? We need development, but at the same time, not at the compromise of the lives of the people, not at the compromise of the people who are below poverty line, not at the cost of the people who are socially or economically disadvantaged. So I'm thoroughly convinced the idea of these ideas and measures what the Dr. JP is proposing, and now I'm also looking forward to have more and more information and the directions from our Honorable Justice Venkatacharya Garu and Dr. Duvur Subbarao Garu. Personally, I feel very happy, and I thank Dr. JP and his team for giving me this opportunity to be part of this historical event. Thank you very much, and I wish all the best. Thank you.
Thank you, sir, especially for highlighting the need for all stakeholders to come together to address these challenges. We hope your insights will be in the coming days. I now take this opportunity to invite Justice
Sumedha, we didn't hear you.
Sir, can you hear me now?
Yes, I can hear you.
Okay,
Yes,
thank you,
yes.
sir. Thank you for your insights, especially for highlighting the importance of all stakeholders to come together to address these challenges. And now take this opportunity to invite Justice Venkatacharya to deliver the inaugural address.
Thank you. Jayaprakash, Narayan ji, esteemed Dr. Subbarao, Professor Raj Shaker, Ashwini ji, all the distinguished invitees and participants. I'm an extinguished judge, but I spent 50 years in law, some 26 years as a lawyer, and then 22 years as a judge and then the Human Rights Commission. My impression is that every human weakness is exaggerated by power. Every power has an inherent tendency to run to excess. The message of rule of law is that let no man be trusted with absolute power, timed down by the restrictions of the law. The primary concern of rule of law is to civilize power and control its abuse. Every case produces a new definition of rule of law within the broader framework. And this meeting is concerned more with the practical applications of the principles of public law in the management and punishment of crime, in the investigation, prosecution, and punishment of crimes. The paper which they have produced, the advocacy paper, is an excellent mirror that shows up the deficiencies of the Indian system in comparative terms. But one or two things there: number of judges per a particular population may not be a very appropriate idea. How many judges are for a million cases is more relevant. In this country, large number of people have nothing to litigate about. They have nothing to go to court with. And the proportion In fact, India, they say there's a docket explosion. I say there's a docket exclusion. In the United States of America, for every 1,000 population, nearly 300 actions, not an assertion of rights, 300 instances of assertion of rights of citizens are litigated, not necessarily in court. And in Singapore, the figure is 89 or 90. Literacy level and the income levels are the same, almost the same. But why is America 300 number of cases that come before tribunals and for dispute resolution, and why only 89 or 90 in Singapore? America is an open society. Singapore is a closed society. The corresponding figure at one point of time was 29 in Kerala, 4 in Jharkhand. So we don't have a docket explosion, we have a docket exclusion. And I think more and more rights have to be adjudicated. People, even educated people, who have means, are reticent to go to a court. And that's the kind of thing that we have built up. In 1991, I'll narrate an instance which I was in the Supreme Court for 4 years by then. Mr. Parkiwala was a great lover of the Supreme Court. And he made a statement that Supreme Court has got into such a mess that it will take 300 years for it to cleanse itself of the mess. That was a statement made out of love for his love for that institution. And the intensity of that love produced the intensity of that language. But judges were quite disturbed about it. They were concerned about it because it came from a man like Parkiwala. The judges met, and Kania was the Chief Justice. He was really concerned how Mr. Patriot could say that. And of course, the judiciary was a mess. But to say that it would take 300 years to cleanse the mess is a little cynical. And what happened was, the Economist of London came out with an indictment to the Indian Supreme Court. There was an article which was not accurate in its facts, but it was a critical article. The judges discussed it, and I was quite, and the Chief Justice asked, why don't you say something? I said, my respect for Parkiwala, whom I had personally known so well, is such that we should not sit in judgment over it, but we must say what corrective action we must take. The Chief Justice then said, you be in charge of the case flow management of the Supreme Court hereafter. I said, look here, I can assist the court, the management, but I can't, in addition to my judicial responsibilities, I can't take over case flow management unless I'm the Chief Justice. Anyway, we looked into the matter. We had, I'll take only a couple of minutes to tell you something which is factually maybe interesting, relevant to this topic. We had about 167,000 cases pending in the Supreme Court on that day in the year 1991. Over the next 8 years, we added an average of 40 to 44,000 cases per year. That would amount to about 300,000 cases. The opening balance was about 187,000 or so. We had to account over a period of 8 years. We had to account for somewhere between 4.5 to 5 lakh cases. My successor Chief Justices, Justice Ahmadi and Justice Verma, were great managers, excellent handlers of case flow. At the end of Verma's term in 1998, I think in February 1998, the total pendency of the Supreme Court was 19,200 to be precise. We had to account for about 4.5 to 5 lakh cases over a period of 8 years. It came to 19,200. It's about 65,000 today. It doesn't matter. It was fast moving into a zero-error court. And there are known tested methods of case flow management. And my problem today is not so much as the arrears in court. They are all a reflection of a deeper malaise. The collapse of these institutions, miscarriage of justice are not unknown in advanced countries. You have the famous the English Birmingham 7, Guildford 4, the great miscarriages of justice that led to an introspection by the British government. They established what is called a Criminal Justice Review Board. Even after the House of Lords decides a matter, if the Home Secretary is persuaded to believe that there is a miscarriage of justice in a particular case, that Criminal Justice Review Board will take up the matter and refer the matter back to the judiciary for a reconsideration. That's the court of last resort, as we call it. This is how things worked out. In India, in the district level, 70% of the cases are criminal cases. 30% are civil cases in the district level. There is a dramatic reversal of the proportion when it comes to the high courts. In the high court, the 70% will be civil cases and 30% alone will be criminal cases. That itself is an indication to know why the 70% became 30%. If the solution is not in the problem, it is nowhere else. You can't fall down in a particular place and get up in some other place. It is only on the strength of the ground on which you have slipped and fallen. It is on the strength of that you can stand up. And this sharp insight into the process will tell you where the defect is and where this defect, despite being aware of it, we have pointed it out 100 times to the government. This dramatic preponderance of power of the state over an individual in a criminal trial, the dramatic preponderance of power. And this is what we should think about. How do we protect people from power? Protection from power is the most important thing. Judicial power or the prosecutorial power or the economic power. How do we protect people from the distortions? I'll tell you one instance in which there is a prosecutor, district attorney in the New York Southern District. That's the most crime-prone district in the American system. New York Southern District district attorney was a prosecutor, was one gentleman of Indian origin by name Preet Bharara. He wrote, after he demitted office, he wrote a beautiful book. It's called Doing Justice. He spoke of an investigating officer, a 6'2" tall fellow and a very tough policeman who took his job absolutely seriously. There was a man who had been imprisoned for murder and sentenced to imprisonment for life, had already spent 17 years in prison. In another case, a man sought for amnesty, pardon. As a witness, he wanted a pardon. In America, if you seek a pardon for a person, he must disclose an affidavit all the other crimes he had committed earlier. And that new man who wanted pardon had listed the crime for which the other man had been convicted and was serving a sentence for 17 years as one of the crimes that he was responsible. This tough police officer took up that matter, re-investigated that case, and got that 17-year-old prisoner who had spent 17 years in prison, released, and got him a compensation of $2 million. That is the kind of prosecutorial justice, fair disclosure. A prosecutor has the duty for fair disclosure. These are some of the examples of even a very tyrannical system. And persons make the difference. How do we make persons make difference in the personal? How do we make them think the way in which law wants them to think? Jayaprakash Narayan is a great optimist. Great optimist. I believe that in society, the kind of the degradation of our society. In science, there is a phenomenon called, in physics, in nuclear interaction, there is a concept called a critical mass. Without infusion of any further energy, the cycle gets into a chain reaction. Nuclear reaction gets into a chain mode, chain reaction. Similarly, if disillusionment with authority, disillusionment with the values of our system, civilization, 30% of the population becomes disillusioned about their faith in their society, there is a social negative critical mass which makes them cynical. And this cynicism is not a power of reconstruction, it's a power of destruction. And some such thing has caught hold of our society today. Even the best of men are dismissed as some kind of a make-believe thing. And the most interesting thing about litigation is that I have calculated in some other context the number of people who come to courts and go back without any work being done. If you take the loss of man-hours and loss of productivity and the number of persons who come to court and go back without their work, any progress being done, you calculated that there are 200 or 300 rupees per day per head. The calculation reads somewhere about 2 lakh crores a year that the judiciary imposes this kind of insensitive lack of productivity, lack of man-hours and the citizenry, let alone the disappointment side of it, this disenchantment side of it, the problem of the economic consequences, and this is immense. Somebody worked it out and showed it to me. There are a lot of good work being done. Ms. Jayaprakash, I think you should summon them. There is an institution called Daksh in Bangalore. Harish Nalsappa is a barrister who handles it. They have done an enormous amount of work. And there is one indefatigable old man by name, businessman by name, I think he's a lawyer, Bhagwan Das Rayani. You must have heard of his name. He, for the last 20 years, he runs an institution called Society for Fast Track Justice. And the number of conferences he has convened, maybe he may run into about 20, 30. And even last month he was online. There was some program that he has been conducting. The whole problem is I'm told in the back of the chair of the American president in the wall there is a board. I have not seen it, but they say the buck stops here is the board. Behind the chair of the prime minister or the law minister, there is no such. The judicial buck stops here. And behind the chair of the, of course, I have sat on that chair myself. And behind my wall, there is no board. The buck stops here. I don't know where the buck stops. But the one good thing about it is that there is an awareness, increasing awareness, their frustration, and a sense of despondence that has come up. And what I wish to suggest is, in fact, it happened in one of the phenomenon that informs the failure is the uncertainty of the law. Law must be known and knowable. Law must be known and knowable. In fact, in the very first case in 1951, there's a case where law had not been promulgated in the manner required by a proper thing. That's called a Harlas case in 1951. I think some kind of a case in which court said law is not knowable at all. This happened in a very interesting case in England. Judges had reserved a judgment almost saying that they would proceed to produce an order on some predictable lines. After they went through it, they were astonished. This happened in the year of 2008. They came out with this statement. I'll read only this small part of it. There is no comprehensive statute law database with hyperlinks which would enable an intelligent person by using a search engine to find out all the legislation on a particular topic. This is what they said about England. Let's imagine what happens in India. This means that the courts are in many cases unable to discover what the law is. What the law is or was at the date at which the court is concerned, and are entirely dependent on the parties for being able to inform them what were the relevant statutory provisions which the court has to apply. This lamentable state of affairs has been raised by responsible bodies on many occasions. This is the state of law in England, and you can imagine what it is in India. I'll tell you a small personal incident. A former Chief Justice was my guest in Delhi after retirement. He had come there for a treatment, and I had requested him to be my guest. He was with me for some time, and after he recovered, before he went, I invited all the judges and their members of the family for a dinner. Before the letters of request went, I asked my secretary, is there any restriction of sumptuary laws, guest control order or some such thing? He said, there's nothing, sir. In Delhi, there's nothing. Every wedding is attended by 4,000 or 5,000 people. There's nothing like that. I said, your general knowledge is not what I want. Please ask the person to find out. Then they came out in the year of 1993 or 92 that there was a guest control order that I couldn't entertain more than 15 or 20 people unless it is a wedding. The number is some 100 or something. Every day in Delhi, the thousands of people attend hundreds of this kind of parties. So before I said, I split the list of guests into half. Invited 15 of them in the first day, another 15 the next day. See, and there's no means of straight away knowing what the state, because what was happening in Delhi was exactly the opposite of what the law required to happen. So this is what in England they pointed out, and it is so here. We don't know unless in a particular case the lawyer, after the case commences, the lawyer will examine whether the law is applicable or is a law at all. In fact, it happened again in England. That's R. was Davis. That also happened sometime in the 2010 or somewhere thereabout. A man killed two persons and ran away to America. And he was caught, brought back. And the witnesses said, if we depose against him, our lives are in danger. The police thought that their apprehension was justified, that their fears were justified. So they appealed to the court. The court said, we will examine them as anonymous witnesses. We'll keep their identities hidden, and we'll instruct the defense counsel not to ask them any questions about their personal identity. Their voice will also be modulated through electronic devices, so that their voice can't be identified through their voice. So this procedural adaptation was made by the trial judge, and he convicted him. The Court of Appeal rejected the accused appeal and confirmed the conviction. When it went to the House of Lords said this is violation of all the principles of rule of law. The person can't be convicted on the basis of an anonymous witness whose identity and credibility the accused had no opportunity to test. So they quashed it. There's a furor in England. And everybody said this is going to be the onset of a reign of terror by terrorists and others. The law was amended. Criminal Evidence Witness Anonymity Act of 2008 or 2010 was enacted just 33 days after the judgment was rendered by the House of Lords. Just within 33 days they made that law. And the response of the legislature was on account of the furor that arose after that acquittal of that case is called R versus Davies. I think 2008 or 2010 was the case. Here they are dealing with, there is an act in America called the Patriot Act. The word patriot is an abbreviation of the expression providing. Patriot is providing appropriate tools required to intercept and obstruct Terrorism Act of 2001. This came up before the American Supreme Court in Boumediene versus Bush, Ramzan versus United States and all that, the Guantanamo prisoner cases. The argument of the American government was the Supreme Court was that you have no jurisdiction for habeas corpus because they are held in a territory outside America. It is not American territory. We have leased it out from some other thing, and they are all prisoners of war, so you have no jurisdiction. In a very refreshing judgment, the American Supreme Court rejected it and said wherever you exercise American authority in whichever territory and people are affected, we have jurisdiction. They quoted the old Mansfield rule in England. They said wherever Britain has authority over land and people, court has the coextensive jurisdiction. This is the kind of thing that happened in this Patriot Act was pleaded as a justification for excluding the court's jurisdiction. Ladies and gentlemen, the principle. How do we go about it? For example, forensic laboratories. You have said we have 14 or 15 of them. There are 417 in America. Yeah, this is a beautiful paper. I think there should be, it's a very well-researched paper which gives all the comparative statistics. It will show how, for example, in India, there's one gentleman was Gandhi, Mr. Gandhi, who started a beautiful institution. He called it the Truth Lab. I think he's from Hyderabad. He's a former police officer who took a retirement and started this thing. It's an excellent thing. In fact, I remember I requested Chidambaram in those days to inaugurate that laboratory in Delhi. And I went there, and Mr. Gandhi did splendid work. Splendid work. Nobody took it. Of course, he was an expert scientist himself, though serving in the police department. He did a splendid idea. It's a splendid idea. He did extraordinarily good work. And at one point of time, we repeatedly pointed out from the judiciary the inadequacies of this forensic laboratories. They would take years together to send a report. They would say, and it's a terrible thing. Now I think things are slightly better after some kind of awareness is coming in about the scientific evidence. And what I wish to say is the whole philosophy is that what we want here from our authorities is, oh God, make me holy, but not today. This is oh God, make me holy, but not today. I have some other things to do today. Let me think about it. Everybody is aware of in fact, I must tell you, Mrs. Jayaprakash, I initiated as chairman of the National Human Rights Commission, a insightful study into the state of this forensics laboratories. We requested a very knowledgeable additional secretary in the Ministry of Home Affairs, one Dr. Tiwari. He went and produced a beautiful document. We published it. And the then Home Minister assured us that he would take immediate and prompt action. And we are yet to see any action on the basis. The report was so excellent, so contemporary. I mean, I'm speaking of 1998, 99, when I was chairman of the Human Rights Commission. And Dr. Tiwari produced a beautiful document. The German ambassador who saw that, he called on me and said, if your government is prepared to take up this thing, the German government will cooperate with the scientific collaboration. He didn't say financial, he said scientific collaboration, will ask our scientists to collaborate with you, with your people. And I think this is the least priority area. And you have highlighted a very, very important area of our concern, law and order, punishment of crime. And these are the things which are great concern, contemporary concern. I don't know how they will go about it, but then please look into what Mr. Harish Nasapa's Daksh has done. And in the civil side, they have suggested very important things. And there was recently a good book by one Richard Susskind. Have you looked into it?
Yes, sir.
He says that the title of that book is Online Justice, Future of the Courts. He has mentioned how in the tribunals in England already a lot of work is done online, and the virality of the process is confined to a small gap of say 15 to 30% of the procedure time. And there are a lot of things that have been already on the card. You must, I think your effort from your institution will be more comprehensive if you include what has already been recommended and under consideration. There is a good committee constituted by the Supreme Court with two judges of the Supreme Court for the absorption of technology, modern technology in the process. And I fought a battle with the government. Of course, the government was quite sympathetic. They gave us a lot of money to start the National Judicial Academy at Bhopal. Yeah, have you been there, Mr. Jayaprakash?
Several times, sir.
Several times. I started that, and it was because of the generosity of the Prime Minister's response that it was possible, because we had to spend a lot of money. And it's I must tell you, as a campus, it's the best campus anywhere in the world. I've seen the American campus for judicial in Reno and all that, but comparatively, it is. I think the issue could be taken there and discussed. Invite judges, trial judges, appellate judges, and take it forward. Thank you for inviting me. I took a lot of time. Kindly. I must tell you, you have empaneled very, very eminent people. I don't know Dr. Subbarao personally, but I know I've read his book, Who Moved My Interest Rate. There was another book called Who Moved My Cheese earlier. and Dr. Subbarao titled his book, Who Moved My Interest Rate, some time ago. Thank you very much for inviting me. All the best to you. I wish every success for your effort to induce some sense into the system of administration of justice. Thank you very much, sir.
Thank you, sir. Thank you for a very insightful inaugural address. I'm happy to inform you that out of the 4 people or institutions you mentioned, 3 of them are involved in this conference. Harish Narasappa is addressing the conference on 28th of February on judicial standards and accountability. Dr. KPC Gandhi is a key player and he's involved in the forensic infrastructure. I think today is the session. National Judicial Academy, Justice Raghuram, the present Director General, is participating. He's chairing one of the sessions. We will certainly reach out to Mr. Bhagavan Das Rayani and follow it up. Thank you very much, sir. It's never too late. We believe that things can happen. Take forensic infrastructure, or back of the envelope calculation is we require about 5,000 crores one time for infrastructure building, maybe half that amount every year. This is small money for the country if only we care. Money is not a big problem. I'm sure this can happen. But with your blessings and support and all the people who are working in the field, we'll do our best to make it happen, sir. Thank you once again for your very wonderful, illuminating inaugural address.
Thank you, sir. Thank you.
Sumetha?
I now request Dr. Subbarao Garu to deliver the keynote address.
Thank you very much. First of all, my thanks to all of you, particularly the organizers of the conference, the University of Hyderabad, the Foundation for Democratic Reforms, and the Indian School of Business for inviting me to give the keynote address at this conference. It's an honor and privilege to which I attach a lot of value. Before I speak, I want to compliment Justice Venkachalaya for his very erudite, insightful, and pragmatic speech. I really enjoyed it and I learned a lot from it. Dr. Jayaprakash Narayan suggested that I focus my comments on the importance of the rule of law for economic growth. Just a thought experiment. Maybe about 500 of you are tuned into this conference now. At the end of the session, you'll have lunch, then you'll go to work in the afternoon. In the evening, you'll go home, have dinner with your family and your children. You're not worried whether you have enough money to feed your children today, this week, this month, or this year. You're not worried about whether you have enough money to fill petrol in your car, or pay the rent for your apartment, or pay the EMI for your house. If your child falls sick, you're not worried about whether you have enough money to take her to a doctor. Of course, you're worried about medium-term things, your children's education, their jobs, their careers, the world in their lifetime. But you have no immediate worries. You're materially secure. You are fortunate. Nearly 200 million people in our country are not so fortunate. They struggle with basic problems of survival and subsistence. Can they feed their families today, tomorrow, this week? If a child falls sick, can they take her to a doctor? They've erected a dwelling on an open site with the government accommodating them. Will the money lender come and take away their belongings because they're unable to pay back the loan that they took from them? India is a poor country, 200 million poor people, per capita income of $2,000. In contrast, rich countries, America, Sweden, Denmark, Norway, Switzerland, their per capita income is $60,000, 30 times our per capita income. Why are some countries rich and some countries poor? Why are countries in the world divided by poverty and plenty, prosperity and penury, health and sickness, food and famine? This is a question that has engaged economists for several centuries. The first economist, Adam Smith, wrote his book, The Wealth of Nations. Actually, the full title of that book is The Wealth of Nations, an inquiry into the nature and causes of the wealth of nations. That was in 1776. Exactly 200 years after that, in 1976, Gunnar Myrdal, a Nobel Prize-winning economist, wrote his book, Asian Drama, an inquiry into the poverty of nations. In 200 years, our attention shifted from the wealth of nations to the poverty of nations. We still don't have an answer why some countries are rich, some countries are poor. Economists have given their own explanations is its geography. That countries in tropical latitudes are hot, people are lazy, lethargic, they're prone to disease, productivity is low, the soils are infertile, thin, therefore countries are poor. But Singapore is a contrary example which defied geography. Then economists said culture, that poor countries, people have no work ethic, they have no inquisitiveness, they have no curiosity, they don't invent, in contrast to the Protestant work ethic. But then culture doesn't explain everything. People said ignorance, that poor countries don't know what to do, what's the right thing to do. But that too is not an adequate explanation. Resources. Poor countries don't have enough money. They don't have resources. Japan, a spectacular example of a country without any resources. From the time of the Meiji Restoration in 1870 to 1950, in a matter of 80 years, has transcended from a medieval country into one of the most prosperous societies in the world, defied resources. So over the last 7 decades, economic development has focused on neutralizing these advantages. Poor countries don't have enough money, so let's give them aid. They don't know what are the right things to do, so let's tell them what are the right things to do. You heard of the Washington Consensus. It's emerged out of thinking like this. Poor countries don't know how to do the right things, so let's tell them how to do the right thing, capacity building. In fact, when I was working in the World Bank, my responsibility was to advise developing countries on how to manage their public finances and their budgets. But still, in spite of this effort over the last 70 years, poor countries are still poor. Their lot has improved slightly, but they're very poor still. Results have been disappointing. So the received wisdom today is that all these things matter. Capital matters, labor matters, material resources matter, but also institutions matter. Institutions including the rule of law. That raises 2 questions. What is the rule of law and why is it important? Instead of trying and answering those questions, I'll give you an example. Korea. Today we have 2 Koreas, South Korea and North Korea. It wasn't always like this. Until 1945, end of the Second World War, Korea was one country. Then at the end of the war, it was carved up into South Korea in the American bloc and North Korea in the Soviet bloc, and the 2 countries have diverged. Today, South Korea's per capita income is 10 times that of North Korea. South Koreans live on average 10 years longer than North Koreans. For homogeneous people, same culture, same geography, same climate, initially started with the same material and human resources. But today, South Korea is among the rich countries in the world, with per capita income close to that of, with standards of living close to that in Europe. North Korea is one of the poorest countries in the world, with living conditions similar to those in sub-Saharan Africa. What explains this? Institutions and rule of law. South Korea is a democracy with an accountable government, a strong and impartial state, and rule of law. North Korea is a dictatorship, an arbitrary state, and no rule of law. So it is the rule of law that explains South Korea's prosperity in the absence of rule of law that explains North Korea's poverty. Let me give you some examples, maybe about a dozen of them, from a closer context that all of you can relate to explain what rule of law is, indeed what the absence of rule of law is. If you're a small farmer in a village, you've been cultivating a land that you inherited from your father for generations. Tomorrow, the Highways Authority comes and says they're going to take away the land for laying a road. They don't give you any compensation because you have no title to that property. That is absence of rule of law. Worse, if the Highways Authority changes the alignment of the road to bypass the land of a rich landlord, but to pass through a small peasant's land, that is absence of rule of law. If you're a biotech lab, you invest crores of rupees in, let's say, discovering a vaccine for coronavirus, and the government does not protect your intellectual rights, property rights, and rivals can copy your work, that is absence of rule of law. If you're a factory owner and you paid a downstream company a huge amount of money for supply of components, and that fellow folds up shop and runs away with your money, and it takes you years to bring him to justice, if at all, you waste so much time, money, effort, that you're completely broken. That is absence of rule of law. If you're a car manufacturer, you recruited 100 people from the IDAW. You trained them for 2 years. You've taken a bond from them that they'll work with you for 10 years after that because you invested in those workers. And after you've trained them, your rival come and poaches them away, and you can enforce the bond. That is absence of rule of law. If the government gives you a contract for an irrigation project, and that government goes away and the next government comes in and reneges on that contract, that is absence of rule of law. If you're an industrialist paying taxes, and then the tax authorities come and say that you have to pay 5 times more tax because a tax law has been amended retrospectively, that is absence of rule of law. If you're a foreign investor, you come in investing on the understanding that the law allows you to repatriate profits. And then the government enacts a law saying that profits cannot be repatriated, and that applies to you, it doesn't grandfather. That is absence of rule of law. If you want to start an industry with 25 clearances, the authorities keep asking you one question after another, delay your clearance, but your rival gets a clearance in a jiffy because he's paid off a political party. That is absence of rule of law. If you're driving on the street and there's an ambulance that has a siren coming and nobody gives way to the ambulance, that too is absence of rule of law. So what is rule of law? I have explained what the absence of rule of law is, and Justice Venkatachalaya has told us very well that law should be known and knowable. So when I looked up rule of law as it applies to economic growth, is clear and transparently written laws. Everyone, and this is important, everyone, including the government, is subject to the laws, impartial and equitable dispensation of justice, property rights, effective enforcement of contracts. So how does the rule of law aid economic growth? We know that economic growth comes from labor, capital, and productivity. When you have rule of law, labor's productivity and capital's productivity, both of them improve. Let me give an example. China, a spectacular example, illustration of going from a poor country to a high middle income country in just one generation. China lifted hundreds of millions of people out of poverty, unprecedented in human history. China is a phenomenal success story. But where did that success start? That success started with the rule of law. Go back to your, turn your mind to 1979, 1980, when Deng came on the scene. What's the first thing he did? The first thing he did was tell the peasants in China that the land is yours, the produce is yours. Until then, China had collective cultivation. People did not have any incentive to produce, any incentive to invest in them. When Deng came and said that the land is yours, the produce is yours, productivity boomed 10 times. Economic growth boomed. So that's the importance of property rights and rule of law. Let me give another historic example. The Industrial Revolution. All of us read about the Industrial Revolution in our high schools. Why did the Industrial Revolution start in England and not anywhere else? People say it's the Protestant work ethic. But more important than that is rule of law. And where did the rule of law start? With England legislating patents and property rights. We associate the Industrial Revolution with discoveries and inventions in textile manufacturing, in metallurgy, in transportation. But beyond all of that is a number of discoveries and inventions. Why did all of them happen in England and in quick succession? Because after the Glorious Revolution in 1688, England enacted property rights and rule of law. So rule of law historically has been important for economic growth. Justice Venkatacharya said that faith is important, faith in the system. I think of that, sir, as trust in the system. Trust in your community, trust in your society, trust in your government, trust in your fellow citizens. Trust is very important, and trust is a part of rule of law. Let me give another example. In Zimbabwe, all of you are Zimbabwe, in Africa, Southern Africa. In January 2000, in Zimbabwe, one of the big banks in Zimbabwe, I think it is called the Zimbabwean Development Bank, had a lottery. The lottery was open to all bank customers who had a deposit of at least 5,000 Zimbabwean dollars in the previous month, in December 1999. So maybe there were about 10,000 of them. All of them were eligible for a draw in that lottery. And that lottery was held open. 10,000 people, lottery, they pick up the lot, and the master of ceremonies reaches out who won the lottery. No surprise, His Excellency President Robert Mugabe. So that is a society, an example of lack of trust. So trust, I think, is very important for rule of law. About 30, 35 years ago, I used to work in the government of Andhra Pradesh here, and I had jobs in industrial promotion. We used to encourage industrialists within the state, from around the country, from around the world, to come and invest in Andhra Pradesh. And at that time, I believe it's even today, states compete with each other, giving incentives, giving concessions to potential investors. If Tamil Nadu says our sales tax is 7%, it's 6%, Karnataka says 4%, Kerala says 2%, and UP says 0%. Then we'll give you free power, free water. Industrialists were quite happy with all this. But when in closed sessions, we asked them, what do you want? They said, sir, low sales tax, free power, free water is all that good. But please, we need law and order, and we need rule of law. Please see that your inspectors don't come to our factories. We will come and give the reports. So rule of law is very important for investments and investors to do their business and to contribute to growth. We want to be a 5 trillion economy. We're at 3 trillion now. We will, of course, get there. But when we get there, also depends on how we get there. What we need for becoming a 5 trillion economy is to grow rapidly. That is necessary, but not sufficient. We need to ensure that the benefits of growth are widely shared. It's only when low-income households see improvement in their incomes, see their incomes increasing, that they spend. That consumption is important for spurring demand. It spurs production, it spurs jobs, it spurs further investment. And we can get onto a virtuous cycle. For that virtuous cycle to be kicked off, to be generated, we need investment. We need investment in services, And importantly, we need investment in manufacturing. And for investment in services and manufacturing, we need ease of doing business. The World Bank ranks countries according to the ease of doing business. We used to rank somewhere in the 140, 130s. And over the last 7 years, since the Modi government has come into office, we've jumped about 70 ranks. We now rank about 67, I think, which is a commendable achievement. World Bank ranks countries on ease of doing business on the basis of how easy it is to start a business, how easy it is to run a business, and how easy it is to close a business. We've improved on that. But there is still anecdotal evidence of how potential investors, entrepreneurs are harassed, frustrated at the front end. So we need to work at that level and improve the rule of law. Just to cite an example, supply chains are moving out of China. They've been moving out not because of COVID, but the movement started even before that because of the Trump trade wars. So over the last 5 years, supply chains have moved out of China, are still moving out of China. And the expectation was that all that will come India's way because we're a large economy. We have inexpensive labor, we have English, democracy, a decent legal system in comparison to China. But yet, all that investment has gone to other countries, bypassed India, Malaysia, Thailand, Philippines, Vietnam, Indonesia. Why has it not come our way? Because it's not easy to do business here. So I think we need to work on that, work on the rule of law, work on ease of doing business so that investment takes place. Investors find it happy and profitable to do business in India. They provide jobs, jobs provide income, support to poor people, incomes go up, and we can get on to a virtuous cycle. So let me conclude where I finished, which is that there are many factors that contribute to economic growth. Geography, resources, capacity, the right things to do at the right time, accountable governments, a strong state, democracy, and rule of law. So if we want economic prosperity, I think we need to focus on the rule of law. Thank you very much.
Thank you, Dr. Subramanian, for that very illuminating talk, establishing a very powerful link between rule of law and economic growth. What it means is that we could do a lot more, and it's well within our reach if only we work on our strengths. There's going to be a major session on only rule of law and economic growth on 26th February at 5:30 p.m. Mr. R. N. Bhaskar, the noted journalist, is chairing. Dr. Montek Singh Ahluwalia, Dr. Arvind Virmani, and Pradeep S. Mehta, they are going to speak. We're grateful to you for these insights, and we'll certainly take that on board and see what best we can do to persuade the lawmakers and the governments to institutionalize the right kind of mechanisms to improve investment. Thank you very much. Samantha?
Yes, sir. I now call upon Professor Ashwini Chatre to extend the vote of thanks. Sir, you're muted.
Thank you. I thought I wasn't, but it's always good to be reminded. Thank you very much, distinguished speakers. It has been an absolute, not just an honor and privilege, but also a delight to partner with the University of Hyderabad and FDR in bringing such distinguished voices together to brainstorm about the future of our country. And in the form of a vote of thanks, I can only begin to scratch the surface of both the possibility as well as the chemistry that we all witness in these interactions. And I'm really delighted to see at the beginning of this second edition of the conference that interacting virtually does not appear to have made any negative impact on either our enthusiasm or the enthusiasm of participants who have lined up and are eagerly awaiting the participating in these conversations. So a vote of thanks, therefore, is also accompanied on my part with delight and pleasure, and certainly a lot of hope looking forward. I have two thoughts that I would like to share listening to the address today from Justice Venkatachalaya and Dr. Subbarao. The first, and these are implicit in conversations in the addresses today and in all the discussions that we will have. So to underline some of this, the first is that India is a liberal democracy. It is a choice that we made and a choice that we cherish and therefore seek to protect. And the choice itself gives us direction on what constitutes rule of law, that it is something that not only derives from the Constitution, that is the letter and spirit of how we understand and define and discuss and debate the rule of law, but also in terms of what we want to achieve. We want to achieve freedom. We want to achieve a future where every citizen individually is able to claim participation in a liberal democracy. And that cannot happen without rule of law. It is not something that we can prioritize one way or the other. It is the absolute essence of being a liberal democracy. It cannot be understood or discussed without ensuring rule of law for everyone. So this idea of freedom that is enshrined, of course, in many ways in our Constitution is fundamental. And therefore, rule of law requires us to pay attention to the ways in which freedoms are enabled and maintained and secured. Like Dr. Subbarao said, many of these freedoms have not been secured yet. 200 million people do not have the security of livelihoods to feel secure about the immediate future of their children or questions of hunger. And in many ways, I am very glad this has come up, because we do not often think about security of livelihoods as being encompassed within definitions of rule of law. And it's extremely important. In two ways that I would like to point out. First is the absence of rule of law makes it more difficult to earn an honest livelihood. And like Dr. Jayaprakash Narayan said at the very beginning, of any system that we work for or work to improve must ensure that beneficial, good, pro-social acts are incentivized, are rewarded, and antisocial, negative acts are penalized or at least disincentivized. To that extent, rule of law acts as an amplifier for not just economic growth, but also security of livelihoods for those who need it the most. There are plenty of other sources of insecurity, whether it is the threat of climate change or illness and so on. But to the extent that we can remove rule of law as one of these factors, it will enable people to exercise their freedoms in ways that will not only secure their own livelihoods, but also create jobs and livelihoods for others. And to the extent that we are able to make progress on that dimension, everyone will benefit. It's a public good. So that's the first thought that I feel is implicit in all the conversations that we are likely to have, and I heard from the keynote speakers today that I would like to bring out. The second is the very intimate relationship between property rights and rule of law. And we often, again, think of these as separate elements. There are violations of property rights often seen sometimes implicitly as white-collar crimes, and non-property right violations or crimes or breaches of rule of law as sort of not related to each other. But it is extremely important, I feel, based on the voices that I heard today, that rule of law cannot be subdivided into divisions in such a neat manner. And the proposals that FDR has made and that Dr. Jayaprakash Narayan already indicated in his opening remarks lay it out very clearly that these are not separable in a way that can be administered easily or certainly to anyone's benefit.
No.
It is our duty to make sure that these conversations do not therefore degenerate. And I point this out because it is our tendency. And it's easy to slip into these comfortable categories of white collar crime and blue collar crime, or criminal justice and civic justice. The extent to which we can resist that temptation of falling into these comfortable silos of treating civil justice and criminal justice separately, to the extent that we can continue to believe that these are all embedded in a larger concept of rule of law, which is important in all its dimensions as an amplifier of not just peace and prosperity, but also freedoms on which our liberal democracy must rest and will build upon. None of which I have said is either novel or earth-shattering, but it is my duty, I feel, in terms of a vote of thanks, to ensure that these issues are brought to the fore so that we keep them front and center as we discuss individual questions and issues, without losing sight of the larger goal, that the rule of law in a democracy, particularly Indian democracy, which is a work in progress and will be a work in progress for a long time, the rule of law contributes to peace and prosperity as well as increases our freedoms. Thank you very much.
Thank you, Ashwini. Just one word, sir, let me repeat. We will do our best to bring all the people who worked very hard over the years to improve rule of law apparatus in this country. As I mentioned, Mr. Bhagwan Das Rayani will reach out to him. And we would appeal to you to identify many such people across the country, because this is not something that any group or organization can do alone. And we have to benefit from the extraordinary work done by a lot of fearless people, insightful people who dedicated a good part of their lives to improving the rule of law in this country, as well as other aspects of our democracy. This is not a proprietorial venture. This is merely in addition to the voice of many people, but we'll try and bring the synergies in this whole effort. To the audience, my apologies that there is no time in the inaugural session for question answer session, but the rest of the sessions, I promise you, there will be a conscious effort to give you adequate time for interaction. On occasion, it appears that the internet connectivity is not good enough at various levels. We'll see how best we can improve that. Thank you all for this participation, and there is an exciting 8-day event starting from today, and I'm sure that we can make a huge difference in at least understanding the issues and raising voice collectively. Once again, sir, thank you, Justice Venkatachalyaji, and thank you, Dr. Subragar.
So just a reminder for all the participants, the first session of the conference will be beginning in 10 minutes. Please join us in exploring solutions to the challenges of modern policing. Thank you.
Thank you.
Thank you all.